Peace and blessings. This is another mortgage checkup video, and this video we're going to take a really in-depth look into the actual mortgage. Depending on the state that your property is located in, it could be called a security deed, a mortgage deed, or a deed of trust. At any rate, regardless of the title, it's still going to have fundamentally the same type of information that we're going to go through here. So this happens to be a security deed out of the state of Georgia. And let me make this a little bigger here. So, first thing is, and I highlighted this here, the notice. This mortgage is subject to special rules under the Georgia Fair Lending Act. Purchasers and assignees of this mortgage may be liable for all claims and defenses by the borrower with respect to the mortgage. This means basically the borrower, being you, can sue if you find fraud within your mortgage. Also, there's another notice. This is a mortgage subject to special rules under the Federal Truth in Lending Act. Purchasers or assignees of this mortgage could be liable for all claims and defenses with respect to the mortgage that the borrower could assert against the creditor. Again, basically stating to anyone that purchases your note or your mortgage gets assigned or whatever, that all of those entities, starting from the original lender that allegedly loaned you the funds in the first place, they're all liable if there is any form of fraud that exists. And in 9 out of 10 cases that we have seen, there is. Alright, so anyway, let's go through. The contract starts with definitions and basically just explaining who everyone is. Very important for you to be mindful of. I did another video regarding MERS, which is Mortgage Electronic Registration System. And if your mortgage is listed with MERS, you're going to see an MIN number here at the very top of your mortgage paperwork on the first page. And it's going to give you an 18-digit number. That's the mortgage identification number. And if you haven't seen the MERS video, look on the channel and take a look at that video, because if you are listed with MERS, it could be a situation where your loan's already been satisfied and you're paying on something that's already been paid for. Okay, so anyways, it just gives you the definition: security instrument, the borrower. This is where it lists the homeowners' names. Then also C here lists down MERS. And basically, as you see, it says MERS is a separate corporation that is acting solely as a nominee for lender and lender successor and assigns. And then the lender, this is where it will show the actual lender, people or entity that allegedly loaned you the money. And if you don't get why I'm saying allegedly loaned you the money, is because banks, mortgage companies, finance companies, all of these different entities that so-called make loans, that is a blatant lie. The only people that can create money in our society are people just like you and me, not banks, not finance companies, not loan companies, but we actually create money by way of our commercial energy with our signature. If you don't understand what I'm saying, then pick up Modern Money Mechanics, which was a publication distributed by the Federal Reserve Bank of Chicago. You can Google, and it's an easy read so you can understand how money is actually created. Then here it goes into the note basically the amount of the note, so forth and so on. And then the property, and there's more definitions. So let's go to the next page here. Really not anything up there I wanted to touch on, but I do want to touch on this definition, RESPA, because if you're doing research on your mortgage, you're going to want to look into all of these different acts and all of these different policy guidelines that your mortgage companies have to follow by the letter of the law. No skirting around it, no smoke screens, but they have to follow it to the letter of the law. So RESPA means the Real Estate Settlement Procedures Act, 12 U.S.C. Section 2601 is where you can find that. And basically it says it's implementing Regulation X, 24 CFR Part 3500, as they might be amended from time to time, and any additional or successor legislation or regulation that governs the same subject matter. As used in this security agreement, RESPA refers to all requirements and restrictions that are imposed in regard to a federally related mortgage loan, even if the loan does not qualify as a federally related mortgage loan under RESPA. So there are some strict guidelines with RESPA, as well as TILA. TILA, T-I-L-A, is Truth in Lending Act. There are some really stringent, strict guidelines that must be followed, and there's heavy penalties if they're not followed. But when was the last time you sat down and you really got yourself a cold drink and you got really intimate with your mortgage paperwork? Or did you do like the bulk of us, most of us, we just sign that stuff at closing and never really looked at it again? Well, I've been looking at this stuff for the last almost 3 years, and it's quite amazing how much fraud and how many violations have taken place. Let's go to the next page. See if there's anything I'd like to talk about here. I don't think so. Just because I'm not going through this doesn't mean you shouldn't go through it within your own documents so that you can understand the contract that you have consented to. Let's make this a little smaller here so I can go a little quicker. Okay. Oh, I didn't highlight this, but I am going to read it here. And basically, some people's argument is that, hey, we know these mortgage companies have perpetuated fraud, for years and years, but also people have, borrowed over and above their means, and things like that. So some people are saying, some of these homeowners are also liable, and I wholeheartedly agree. If you falsified documents, if you fraudulently, did things to make it look that like you were credit worthy to receive these loans, and then you went into foreclosure because you couldn't afford the property or whatever, fraud is fraud, whether it's fraud on a homeowner's part or whether it is fraud on the mortgage company's part. Fraud is fraud. And right here, number 8, it talks about the borrower's loan application. Borrower shall be in default if, during the loan application process, borrower or any persons or entities acting at the direction of borrower or with borrower's knowledge or consent gave materially false, misleading, or inaccurate information or statements to lender, or fail to provide lender with material information in connection with the loan. Material representations include, but are not limited to, representations concerning borrower's occupancy of the property as borrower's principal residence. Well, they're pretty much talking about you getting a loan and saying that it's going to be your primary residence, but it's really not. You're getting it for an investment property, but if you're using it as a primary residence, then your interest rate is a lot lower than it is for investment property. So there are some situations where people have done that, and that is fraud. Okay. Let's see. Let's go over to the next page. Okay, this is one you'll want to pay attention to. Borrower not released, forbearance by lender, not a waiver. Extension of the time for payment or modification of amortization of the sums secured by this security instrument granted by lender to borrower or any successor in interest of borrower shall not operate to release the liability of borrower or any successors in interest of borrower. Lender shall not be required to commence proceedings against any successor in interest of borrower or to refuse to extend time for payment or otherwise modify amortization of the sums secured by this security instrument by reason of any demand made by the original borrower or any successors in interest of borrower. Any forbearance by lender in exercising any right or remedy, including without limitation, lender's acceptance of payments from third persons, entities, or successors in interest of borrower, or in amounts less than the amount then due, shall not be a waiver of or preclude the exercise of any right or remedy. Again, this document is pretty much set up to be in favor of the alleged lender, meaning them and not you. And in really starting to research all of this and getting more and more information, I'm starting to get to the realization, or I've gotten to the realization, that contracts, when we contract with entities and we contract with different companies for an extension of credit or whatever it may be, that we don't, as consumers, homeowners, or what have you, we don't negotiate the contract. We just say, okay, this is the contract I have to sign in order for me to get whatever it is, so I'm just going to, glance over it and sign. But a contract has certain elements in order for it to be a valid contract by law. All disclosures have to be stated up front. It has to be a mutually consenting contract, and if you signed it, then you mutually agreed that it was okay. But another point to remember is that all disclosures have to be made up front within the contract. And you can go into, and that's why they put within your closing documents, they put a truth in lending statement that basically says, in the year 2060 is when your loan will be paid off, and if it was a $100,000 loan allegedly, then you'll probably pay $500,000 to $600,000 back. And that's just one of the stipulations, and that's one of the disclosures that have to be stated up front. But everything regarding this contract, all disclosures must be made. And in going through this, we're finding that not all disclosures were stated up front at closing. Okay, let's go to, see here. There's some really, really good stuff in here. And if you don't, if you don't have your original documents, then you can always go down to your real estate county registrar's office and request a copy. And I would request a certified copy in case you are wanting to move forward once you find out that you possibly have been damaged and you possibly have had fraud perpetuated on you and your family, and you want to pursue a remedy to rectify that situation. So I would get a certified copy. Okay, this is the last page here that I really wanted to point out in this video. And this is basically, as you know, in order for a mortgage to be secured by the property, the mortgage as well as the promissory note has to be attached together. Hence, that is why it is secured by real property collateral. The same works with a loan for a car. The promissory note and the loan documents have to be together. So if it's sold, if it's assigned to another entity, or whatever the situation may be, it has to be together in order for that particular loan to be secured by real property, real collateral. Well, what has taken place, and I don't know the exact date, I've guesstimated with my research about the year 2004, 2005, when a lot of securitization was taking place, where your note was separated, and I guess the legal term is bifurcation. Bifurcation is where you separate or divide. And with that instance, when promissory notes were separated and then were actually sold on Wall Street as investments, then that particular loan was no longer secured by real property. At that point, when it went into that trust or whatever investment vehicle being sold on Wall Street, that then became an unsecured loan. And this is another really, really great point that people are bringing up and now, fighting against the fraud that's taking place and fighting against these, entities stealing their property. Because now, if I have a loan that's no longer secured by my real property, then the most that you could do to me is, sue me in court and put a judgment against me. But you can't take the property because it's no longer the collateral for the loan, because you went against the policies and laws as it relates to mortgages, because you separated that promissory note from the actual mortgage. So this is something else that you will want to look into in doing your research on your mortgage. And this points it out here, and it's very subtle in what I've highlighted here, and I will see if you get it. So it says sale of note, change of loan servicer, notice of grievance. The note or a partial interest in the note, together with this security instrument, okay, it's very subtle, together with this security instrument can be sold one or more times without prior notice to borrower. A sale might result in a change in the entity, known as the loan servicer, that collects periodic payments due under the note and this security instrument and performs other mortgage loan servicing obligations under the note, the security instrument, and applicable law. There also might be one or more changes of the loan servicer unrelated to a sale of the note. If there is a change of the loan servicer, here's another good point. If there is a change of the loan servicer, borrower will be given written notice of the change, which will state the name and address of the new loan servicer, the address to which payments should be made, and any other information RESPA requires in connection with a notice of transfer of servicing. Now, get this. There has been, I'm sure you've gone through a couple of mortgage loan servicers yourself on your own property. Now, there are guidelines and requirements that have to be done in accordance to RESPA. Number one, it has to be assigned a certain way. Every signature has to be endorsed on the actual note, and it has to be properly recorded down at the county recorder's office. And well, if I'll say this, if your loan is listed with MERS, that's the way they kind of skirted around having to do all of that, was because they left it in the name of MERS. And so it kind of, not kind of, but it did, hide who the true investor was, who the true owner of the note was. But if your loan is not listed with MERS, then every single assignment has to be fully disclosed. It has to be properly done in accordance to RESPA, and then also it has to be recorded down at your county registrar's office. Another thing too, if you didn't watch the MERS video, watch it, because if your MIN number, if it's inactive, that means you're no longer listed with MERS, that MERS actually assigned out your loan to an actual lender, all of their interests and everything. And we're finding in those instances as well, because once that's done, it all has to be recorded, and it all has to be done in accordance to RESPA, but it's not being done. You've heard of all the stuff that centers around MERS, with the robo-signing, with all of these different things that have taken place, and how at the end of the day, the homeowner is the one that is suffering the most. Okay, read the rest of this. If the note is sold and thereafter the loan is serviced by a loan servicer other than the purchaser of the note, the mortgage loan servicing obligations to borrower will remain with the loan servicer or be transferred to a successor loan servicer and are not assumed by the note purchaser unless otherwise provided by the note purchaser. What this is saying is that basically, if it's not done properly in accordance to RESPA, then the proper holder of the note is the only entity that can pursue any type of foreclosure action. We have right now, across the entire country, we have loan servicers that are initiating foreclosure actions, and they have no legal or lawful standing to do so. And people's homes are being unlawfully stolen from them, and it's being permitted in court because no one is raising the argument. And that's because we, the homeowners, are not educated enough to do this. And the attorneys, God bless you if you hire one of those, they're not educated enough to raise the argument. So my suggestion to you is to get educated, some more. Okay, last thing on this, and then we'll end the video. Okay, Neither borrower nor lender may commence, join, or be joined to any judicial action as either an individual litigant or the member of a class that arises from the other party's action pursuant to this security instrument, or that alleges that the other party has breached any provision of or any duty owed by reason of this security instrument until such borrower or lender has notified the other party, with such notice given in compliance with the requirements of Section 15 of such alleged breach, and afforded the other party hereto a reasonable period after the giving of such notice to take corrective action. This is the portion of this section where it's talking about notice of grievance. And basically what this contract is saying, and this is kind of like a maxim of law, is that, hey, if you're going to sue us, then you need to give us notice, and give us an opportunity to cure or to rectify whatever the situation is. Well, with what we do with our private process, because we don't really go into a lot of public litigation and so forth, statutory litigation, because it's really not necessary. But coming from the private side and getting a remedy, the first thing with any type of legal proceeding is lawful notification. So, I mean, they're just stating the obvious, to give them notice and give them an opportunity to cure the situation. So basically, if you've done all your research and you get to a point where you say, hey, I have had fraud perpetuated against me, I've been injured, I've been damaged, here are my statements of facts, and here is your opportunity to rectify this situation. And it can be rectified and remedied privately between you and your mortgage company, and that's all they're saying here, is to give them the opportunity to cure an opportunity to rectify the situation. Last paragraph. If applicable law provides a time period which must elapse before certain action can be taken, that time period will be deemed to be reasonable for purposes of this paragraph. The notice of acceleration and opportunity to cure given to borrower pursuant to Section 22 and the notice of acceleration given to borrower pursuant to Section 18 shall be deemed to satisfy the notice and opportunity to take corrective action provisions of this Section 20. Now, that's a mouthful, but basically, again, what they're saying is reasonable time frames. You can find that also in the Uniform Commercial Code. I think it's Article 1. I just read that. It's Article UCC 1-204. It's time, reasonable time, is the title section there, and you can kind of read that. And that's what they're talking about here, is time frame with your lawful notification and different things like that if you're going to pursue some form of litigation, whether it be on the private side or in the public court system. So that is really taking an inside peek and exposing a little bit of what is really inside your mortgage documents. There is a lot more there, and again, I encourage you to pull your documents out and to sit down and to read the contract that you have signed up for. And this contract is not, all said and done. If you find that the contract that you've signed, once you read through it, you discover certain things that are not in your favor, that don't benefit you and your family, then you can renegotiate another contract. You can renegotiate another contract, because you're not forced to be in any type of contract if it does not serve you, if it does not benefit you. And so that's some of the things that we do on the private side as well, getting remedies and so forth. Another thing that you may want to entertain is to have a complete mortgage analysis done for you. If you don't have the time, you're not really knowledgeable enough to really see what's taking place and how you may have been injured, damaged, or had fraud perpetuated against you, then that's something you can actually go to True Wealth Society indepth.com/mortgage analysis, and you can read up excuse me, you can read up on our information and the service that we provide in giving mortgage analysis to homeowners across the United States. So that is it for this video. Leave your comments and so forth down at the bottom, and I'll see you in the next video. Have a great day. Peace and blessings.